I'm Whitney Sedwick Meister, an employment attorney at the law firm of Fennemore Craig. Today, I will be talking to you about restrictive covenants designed to limit or prevent competition by current and former employees, and agreements which can help protect a company's confidential and trade secret information from disclosure by current and former employees. In many states, including Arizona, companies can contractually obligate current and former employees to limit the employee's right to compete against the company after the employee is no longer working for the company. These contractual obligations are commonly referred to as restrictive covenants. One type of restrictive covenant is a covenant not to compete. A covenant not to compete generally prevents a former employee from working in a business or owning a business that competes with the former employee's company. Another type of restrictive covenant is a non-solicitation covenant, also called an anti-piracy agreement. A non-solicitation covenant can restrict a former employee from soliciting the company's customers and customer prospects, as well as other employees. The law provides that a company must tailor the covenants to ensure that the restrictions are no broader than the company's legitimate, protectable interests. If the covenant is too broad, it will likely be found unenforceable. To determine the appropriate parameters of a restrictive covenant, the company must engage in a fact-specific inquiry and take into account all of the circumstances of employment. To determine the appropriate geographic scope and duration of a restrictive covenant, an employer should consider the nature of its business and the specialized knowledge of the employee. Ultimately, the limitation on the employee should be no broader than necessary to allow the employer a reasonable period of time to replace the employee, train the replacement, and maintain the goodwill created by the departing employee with the employer's customers and prospects. A reasonable restrictive covenant should not cause undue hardship to the employee or a potential injury to the public, such as in the case of a special relationship like one between a doctor and her patient. In addition to restricting current and former employees from competing against an employer or soliciting an employer's other employees or customers, employers should consider requiring its employees to enter into confidentiality agreements to protect an employer's confidential, proprietary, and trade secret information, which is often a company's most valuable asset. A confidentiality agreement should define a company's confidential, proprietary, and trade secret information and clearly set forth the employee's obligations when it comes to treatment, use, and disclosure of such information. For example, a company can require that an employee not disclose any of the company's confidential or trade secret information to any individual unless such disclosure is necessary for the employee to perform his job. In addition, a confidentiality agreement can provide for the manner by which an employee is to return all confidential information upon termination of employment. For example, a company could require that at the time of termination, all such information be returned to the company, that the employee not retain any such information in any format, and that the employee sign an affidavit affirming that he has returned all confidential information, is not in possession of any confidential information, and has not improperly disclosed or used any confidential information. As determining what is a reasonable and enforceable restrictive covenant involves a complex legal analysis and confidentiality agreement should be tailored to the particular needs of a company, we recommend that legal counsel is consulted when drafting these agreements. If you have any questions, please don't hesitate to contact me. My name is Whitney Sedwick Meister.